Okay. Okay, so please.
So, good afternoon, ladies and gentlemen. We have now our conference in our ELPIS meeting, and we are talking about the AI. What's new in AI? What's new from the point of view of technologies, but also what is new from the point of view of the war? Because as you remember, in the last meeting, we talked about some new things arriving, and we said that it was expected that after the AI directive, we should have some legal norms from the national point of view, because what the European Community has done was to establish a global frame, and that frame needed to be completed with the laws of the different countries. For instance, if you think about the penalties they are established, those penalties could not be applied in an internal point of view without more densification, because otherwise they look sometimes like what we call the white norms. They have no application, they need to be densified. So we were hoping that new things arise in the field of in all the countries of the EU. But as far as I know, we can be a little bit disappointed about it. Because if I look at the Portuguese situation, the new government made just one thing to the agenda. He said, we are now doing a program for digitalization. We are very proud of doing this program. We will have a commission, and that's all. They did not know. And in some other countries, it happened the same. In Spain, I believe, in France, in Germany, they had already some rules. There are probably some arrangements, but there was not a war in any other place but in Italy. Italy, in this case, was the exception, and I hope it's a good exception because they try to do their work, and we are talking about it. One of the persons that intervene in this panel is Professor Elena Buoso, that will talk about the Italian experience. So I don't know if it's a consequence of the situation, the crisis, the war, all these things together, but the opportunity that we thought that was open to densify the legislation on AI did not happen. And from the point of view of war, that's more than necessary because the AI is something that is unavoidable, and we must prepare for everything. As you know, there are two philosophies on the matter. The American one, they say they don't need no regulation whatsoever. It's a question of freedom of speech. I think it's a little bit strange talking about freedom of speech and computers, but that's the way they do it, and that's the way they put things. So normally they are against regulation. On the other hand, there is the European perspective. And from that point of view, we need some regulation. And you already prepared that regulation, and now we hope that the states can help and densify all the questions. And looking to the situation in Portugal, and looking at constitutional and administrative law, from the point of view of constitutional law, we don't have many problems. There is the Article 45 of the Constitution that establishes the rights and duties in the matter of AI. In the beginning, there was nothing. That article was about the files that were in the hand of an administration, but it changed, and now it gives a full protection to the citizens and a full regulation for the internet. And then there is a charter. We like to be fashionable. The French had a charter. The charter became something fashionable, and deputies decided to do a charter. As a matter of fact, the charter that promised a lot did not that much, but try to solve the situation where there could be a cohesion of rights. And in a general sense, from the point of view of constitutional law, we have no problems. But on the point of view of administrative law, we do have lots of problems. Because, in my belief, there are two main questions when we talk about AI. The first question is the freedom of speech, all the freedoms in general. The second problem is how to control AI, how to control the algorithms. And this question has to do with administrative law. If you look at Portuguese administrative law, there are general norms. In the administrative procedural law, there is a general norm that says that technical activity is regulated by the code. But that was a general law that was created 40 years ago. Nobody thought about AI, but it works. It's a provision, it's general, it works. On the other hand, in the Constitution, there is a law, there is also in the administrative process code that says that no matter is formed, any administrative operation can be verified and controlled by a court. It's a general provision, but it works. So the problem is not the possibility. The possibility is open. The problem is that nothing else than the possibility is regulated. There are no special provisions for using the AI in administrative law. To give you an example, in 2015, the legislator of the reform of the Administrative Procedure Code created a norm that said administration can use a computer. My God, did we need that law to have computers in the administration? No, it's not a law of an authorization because it says nothing about the relations between AI and the persons, between all the laws and all the rights that can be engaged. So in our administrative procedure, there is not even one procedure that deals with questions with digitalization or AI. We have the general provision. They are supposed to be submitted to the Administrative Procedure Code, but no application. Looking at the administrative process, the same problem. There are no specific provision applied to AI. There's no provision about the control of the algorithms. There's no provision not of principal means nor of special means, preventive means, urgent means. So we have all the possibilities, but we don't concretize yet these possibilities. And we need to densify the wall. We need to densify the wall because we have problems of cohesion with fundamental rights, problems of cohesion between principles. One problem that we have now, and it happens in all the countries, is how to connect the principle of openness of administration and the control of the protection of the persons. Because there are some interpretations that come not from the publicists, but come from the privatists, and they say we have to protect everything. Everything must be anonymous and secret. But how can you do an administrative act that is public anonymous? You can't. That's the end of the control. That's the end of administrative law. If you apply to a subsidy, if you apply for an administrative act, you need to know not the one who won the competition, but the names of all the others in order that you can have a process against them. And that needs to be regulated, and it's not. There is a problem. Nowadays, if we look at the general courts, they defend the privacy. If you look at the administrative courts, they tend to defend the publicity because it's public law. And because of that, there was a huge discussion in my faculty, and one dean decided that he didn't have to publish the minutes, which is something unbelievable, because the minutes are the proof of administrative acts, and they are not protected by any secret of any person. A person that applies to something, a person that took a decision, is in a public organ, takes a public decision, that has to be published. But these problems are arriving, and not just in Portugal, as far as I know. So we need, from the point of view, especially of administrative law, we need to have more provisions dealing with AI. We need to have special procedures about the use of AI by public administration. We need, on the other hand, from the point of view of administrative process, to say there is a special mean, a preventive mean to deal with algorithms. We have to create urgent means to deal with AI, and we need to apply all the possible actions. And in Portugal nowadays, in our process code, we have the possibility of condemn the administration, to annulate the acts, to determine the rights of the people, and so on. But we need to have special provisions regarding digitalization and AI. So, from my point of view, and from the point of view of Portuguese law, we miss this opportunity until now of regulating more, densifying more what has to do with administrative law, procedure and process. But after having told that, a kind of introduction to the team, now I'll give the floor to my colleagues in order they can talk about the situation in their own countries, kind of a balance that we can do here among specialists. And I'll give the floor first to Professor Balaguer Callejón. There is a well-known specialist in the matter. His book, The Constitutional Algorithm, it's already something important in the administrative doctrine and in constitutional doctrine, and also administrative, but in constitutional doctrine. And another good thing from the writings and the talks of Professor Balaguer is that he has a great sense of humor. And the last thing he sent to me in the conference we organized about the rule of law, the intervention was called the computer, the mouth that speaks the words of the law. The algorithm, the mouth that speaks the words of law. So without further ado, when I give the floor to our colleague and friend, Professor Balaguer.
That's okay. Now it's okay.
lì nella waiting room, non riesco a vedere il mouse dov'è. Qua. And maybe,
This is it.
okay. So,
Oh, my.
okay.
Hi. Thank you, Vasco, and thank you for. Okay. Thank you. Now? Thank you, Vasco, and thank you for inviting me again to our interesting conference. I agree with Vasco in everything in relation with the situation in our countries, in Spain and Portugal. I don't know, but I suppose it's almost the same in Germany. We have not yet completed regulation. We have the experience of Italy that had a very good law, and this is interesting because the law tries to do something different to incorporate a national vision, a constitutional national vision of AI, of regulation, and complete in that way the AI Act from the European Union. So we think that we had to try more in our countries, and the experience of Italy is interesting for us in the future. I suppose we have different conditions in our countries. In my country, there is a strong commitment, our government in favor of regulation and in favor of AI Act and to complete AI Act, but for different reasons that I don't have time to develop, had to be with the political situation in Spain, the capacity of our government to pass a law in the parliament. They didn't have yet a complete regulation. But beginning with the principle, I would like to try to understand the conflict between regulation, no regulation, or regulation, deregulation, like the strategy of United States, the strategy for AI winning the race. That is a title that means a lot. They try to win in the race and to become not the first, because they are the first at the moment, but continue to be the first in the future against China and again perhaps other aliens in the future. So winning the race, that means they try to avoid the European regulation and the national security strategy that is in the same sense against European regulation. And in that case, I will say also against European Union. It's both strategies were in the last year, July and November, and both are clearly oriented against regulation. But I have to say, in the 3 days ago, so this week, Trump administration changed the idea and began to say that they will need a regulation for the future. Why? Well, I will try to explain also that in my lecture, but for the moment, I would like to try to understand, or to make understand the conflict between regulation and no regulation in another approach. As say always my friend Rafael Bustos, Spanish author that know very well AI and digital society, most of the problems that we have now are methodological problems. So we need to understand better the problems. We need to have a methodological approach that could fit the social, the digital society, and we cannot go on without thinking before about methodological problem, because that is the key to understand the substantial problem. And this is easy to understand for us, because we had the same situation at the beginning of European studies. European studies, as you remember, were the same, with the same people researching for many different topics. The same people could research at the beginning about fundamental rights in Europe, about parliament, or about the limitation to the production of milk. That's our topic completely different. We cannot apply the same methodology to understand the limitation to the production of milk and the fundamental rights, because our topics issues completely different. And this is my approach too. I try to understand the problems in a different methodological approach. So when we say regulation, no regulation, what is the problem? Is this a false dilemma? Is this not true? Because that is not the problem, regulate or not regulate. If we think in other fields, for instance, we feel in regulation to avoid the danger, the risks that we have to environment, that knows very well my friend Vasco. So we are regulating one activity, one particular activity. So it's clear that we need to regulate to avoid the problems in the future, to avoid the damage that we can produce to environment. But in the case of AI, we have a very different situation. Why? Because, as you know, AI is based on two pillars, two columns. One is data. We need data to AI because we don't have a lot of data, and a lot of data of quality. AI cannot function. But at the same time, we need algorithms. And that is the question. The algorithms are a part of AI that had a normative function, that had a normative configuration. Algorithms are rules, are regulation. Through algorithm, the big tech companies are configuring the digital society. So we have regulation. The question is not if we regulate or not, because digital society and algorithm are a regulation, a very structured and ordinated regulation to configure the digital society. They decide everything. They decide in social network. They decide in application that we use for create a text or for decide administrative process or to decide in other fields. They have a normative function. They are rules. So we have regulation. So the point is not if we have or not regulation, because we have the regulation that is created now for the big tech companies. The point is who regulates? Regulates the big company, the tech company, in function of economic interest, a model of business, only to produce more money, or regulate the public power, the democratic power, to defend fundamental rights, to defend democracy, to promote the dignity of the person. That is the point. The point is not regulate or not regulate. The point is who regulates. This is also the question when we think in the Trump administration. What Trump administration wants is not the regulation or not regulation. That is not true. If you read carefully the strategy of AI from the United States that is winning the race, you can see that it's a lot of regulation inside and a lot of remission to reference to other norms of action that will be regulated in the future. But what this is doing the Trump administration is to avoid all the regulation, to avoid the regulation from the state. They want to do only federal regulation, and to avoid regulation from the state that could, in some way, control the power of the big tech companies. And of course, they want to avoid European regulation. That is, the focus is to avoid European regulation, because European regulation is not American regulation, could permit to Europe to control the big the technological companies and to promote fundamental rights and democracy against the activity, the regulation that exists from the tech companies. So that is the point. The point is who regulates. And the answer from Europe, as said before by Vasco, is a good answer. We regulate because we need to protect our market and we need to protect also our fundamental rights or our democracies. It's interesting here that we have some kind of paradox. If we think constitutional regulation, the constitutional regulation had to be promoted by the national state because we have constitution in the national state. We have constitution in France, in Portugal, in Italy, in Spain, in Germany. We don't have formally a constitution in Europe. So you need to have for constitutional regulation of AI, you need to be made by national constitution, by state, member state, or other state in other parts of the world. But the problem is, if you don't have a big market, if you don't have a market with the dimension to allow the market established rule that had to be accepted, enforced in relation with tech companies, you don't have the possibility of effective regulation. If Portugal or Spain or any other country, even Germany, try to make a regulation with legal force to the big tech, that will be impossible because we don't have the dimension of market that could be important for that companies to accept the regulation. So, except Brazil, perhaps Brazil had more than 2,000 million of people and have a constitution, a very good constitution, inspired in some way in Germany and in Portugal, in theories of Portuguese constitutionalists and German constitutionalists. And then they have the possibility of regulate and with a regulation that had to be accepted by tech companies. We saw that with the conflict between X from Elon Musk and the judicial power in Brazil. Brazil decided that X from Elon Musk didn't go to continue to make business in Brazil because they didn't accept the condition of the judiciary. So Elon Musk maintained the situation for some days, but at the end decided to accept the condition from Brazil because it was the only possibility to access to a market that had more than 200 million people. Now, we have the paradox is the nation state that had the constitutional conditions to regulate in favor of fundamental rights and democracy, and doesn't have the power to do that. But the EU, the European Union, who has the big market, doesn't have the constitutional condition to produce a regulation directly in favor of fundamental rights and democracy. But here is for my frame of commercial law. Important is to understand that through the regulation of the market, European Union could promote also fundamental rights and democracy. That is really important to understand because globalization and the European Union is a phenomenon that are very congenial. European Union began with globalization to create a supranational market in condition to act with a global market and to defend the interests of national market from the member states. That means European Union had made a positive mediation between global market and national market in favor of national market. In favor of national market means also in favor of constitutional right, constitutional system, and democracy. So it is important to understand that the protection of the European market is not a question irrelevant from a constitutional point of view. Through the defense of constitution of European market, we can protect our democracy, our rights. That is really important. But the paradox continue. The paradox go on. We have European Union is not a constitutional structure and had to defend constitutional positions. And on the other hand, the state, the national state, the constitutional state that could defend the positions, the constitutional positions, had not the market to implement the decisions that could protect fundamental rights against the big tech companies. So it is important that European Union began the way of regulation. This is really important for us, for our constitutional system. But it is not enough. We need more constitutional approach. We need a constitutional approach because the competences of the European Union are competences linked with the market, are competences connected with the market, with the regulation of the market, are not constitutional competences. Even if we have the Charter of Fundamental Rights, but we know that the Charter of Fundamental Rights establishes clearly that the competences of the European Union will not be incremented because of the stipulation of the Charter. So European Union could act regulating the market, but had not the position to establish a constitutional approach on the protection of fundamental rights and democracy for the member state. We need state regulation. We need a state regulation. And here it's important to understand that it's not easy, because we can complete through the state regulation some stipulation of the European Union. But can we go beyond and establish more fundamental protection in relation with our constitutions and protect more in our countries fundamental rights and democracy than those for the moment AI Act and the European regulation? That's the point. That's the point. I think that is possible. It's possible always that state regulation will not interfere in the market. It's possible when you try to respect the European regulation. You establish more conditions in your country, but with respect to the European regulation. And that is the mission that we have in our countries, try to establish good regulation that could approach the EU regulation to our constitutional conditions and make the regulation more similar to requirements of our constitution. That is the function. In relation to Spain, because Vasco spoke about Portugal, I had to speak a little bit about Spain. Spain had a very strong commitment with the regulation of AI and began like Portugal. Portugal made the charter in May, we made in July. The first was for the Portuguese charter of digital rights. A Portuguese charter had a legal force. I don't know really what means that, because it's difficult to think that those rules could be with legal force at the moment, but it's declared that it had legal force. Spain had a charter that is not with legal force, but it's a very comprehensive charter. And after our charters began also European Union in 2023, 2 years after our charters. And then we have also the Ibero-American charter that with all the Ibero-American countries that are declared also a charter of fundamental of digital rights in our time. So we began with the charter. It's a very important step. We have, for the first in Europe, I think, the creation of the agency to supervise artificial intelligence. So it's the first agency created before even that the regulation of AI by the European Union. We have some bill drafts that is, for the moment, I don't think that could be passed in our parliament because the government had not the majority to pass the bills. And then we have, for the moment, a situation that this is not good from the point of view of regulation of AI. The most important bill is from 1 year ago, but is for the moment it's not yet passed to the parliament. It was only a bill produced by the government. This is the minimal application of the European regulation. We need more. We have some other rules established in the last year in relation with other fields, sandbox or cyber security and other fields. But the situation in Spain is not a very good situation, it's a satisfactory situation in relation with the development our tax, what we need to do to develop the European regulation, try to control from a constitutional point of view the big tech companies in favor of fundamental rights and democracy. So that is the situation in the European Union in Spain. We have a change 3 days ago. Trump administration decided that they will implement in the future a regulation. Why? There are many possible interpretations. One could be the new AI created by Anthropic. As you know, there is a AI created by Anthropic that is really dangerous because could be very important against cyber security. It's AI that could provoke a risk in our system, in bank system, in security system, military system, in defense system. This is at the moment is not, of course, for public use. Anthropic gives only to a number of agents the possibility of trying to use and to know how functions this AI. That could be a reason that Trump administration have seen the danger of AI, but it's difficult to understand from that approach because ChatGPT was also really dangerous at the moment when it was produced because it was introduced in the market in a beta version. Was not and this is not already in a condition to be in the market. Could produce a massive disinformation. This is really terrible. The situation of that we have with ChatGPT, and for Trump it was not a very big problem to think again in regulation. So one of the interpretation is beginning with the question that I posed at the beginning of my lecture: who regulates? What is trying to do Trump administration through the new regulation in the future is to avoid the participation of the Chinese companies in American market. That could be an interpretation because it's nonsense, it's contradictory with all the strategies that have been implemented until now for Trump administration, that position from 3 days ago. So who knows? In the future, we will have even more regulation through American administration. And we have also geopolitical conditions that put real difficulties to implement European regulation. Now we are talking about simplicity, about flexibility, because we have a very difficult geopolitical situation in Europe. That comes from Ukrainian war. When the Ukrainian war begins, we began to know that we didn't have the means for our defense, for having the possibility of defending Europe against Russia. And we began to have more weakness in relation to the United States. And since the Ukrainian war, we have begun fragmentation of globalizations. That means we are began to articulate globalization in regional sense through political or geopolitical affinities. That means that we have, for the moment, a difficult situation for the so-called Brussels effect, in the sense that we have a very difficult situation for European regulation. For the moment, China and United States have the leadership of the globalization, of fragmented globalization, and are incorporating negative mediations in favor or their interests of China and United States. As I said before, we had in the European Union for many years the possibility of incorporating positive mediations in favor of the member states and the national markets. Now we have negative mediations in favor of China and United States through the fragmented globalization. That means that we have a very strong pression against regulation in Europe, and that it will be more and more difficult to implement our regulation in those conditions of fragmented globalization. And the last episode of this evolution of globalization is the war in Iran. This war, I don't know at the end how it will be, but in my opinion, will demonstrate two things, at least. The first, that Donald Trump never read Immanuel Kant. That is important, because Immanuel Kant said that the perpetual peace will be achieved through the exchange, commercial exchange between nations, among the nations, because the war is against the commercial interests of the nation, against the economic development. And that is the same thing that for the moment says the World Commercial Organization, say that the interdependence among all the countries is a guarantee for peace. Until now, we can say that in general, it is so. And after the Iran war, if finally the Trump administration accept the end of the war, declared by Marco Rubio in a way that we didn't expect, the Secretary of State will declare the end of the war that was declared by the President of the United States. If at the end we get the peace in Iran, that means that globalization imposed against the war. That is a good news for us, because the commercial relations and the globalization will be a guarantee of the peace in the future. We don't know, we will have to expect. I hope the war will end in the next coming days, and we will happy with the new condition of globalization. Thank you very much.
So now it's time to give the floor to our colleague Friedrich Germelmann. He also is a specialist in this kind of topics. And the German case, it's very interesting, because the Germans were the first to have legislation and regulation regarding AI, There are lots of reforms of the administrative procedure code, of the administrative process code. So they are advanced in this matter, and let us see what are the latest news nowadays. I believe they are not so good as the others, but we have to listen. Thank you very much, my dear friend. You have the floor.
Yes.
Well, thank you very much, Vasco, and thank you very much, dear colleagues, to be here and to listen to what I have to say in this post-lunch hour. What I would like to do is to present the topic that I've been assigned to in 3 installments. First, to give a broad overview of what actually is at stake, and then have a look at what administrative procedure and institutional questions can do as far as European Union law is concerned, and then the German case. Well, I have to announce, or I have to say at the very beginning that as far as German administrative law concerning digitalization and all that is concerned, I have sort of skipped that and would like to talk really about what we are going to do about the new AI Act, so the artificial intelligence questions which are, and where as far as I think I've got the feeling there is already something, not particularly very much, but it is a peculiar, let's say, construction that we've got, a peculiar conception that we've got, and possibly it's I don't know whether it's going to work, but I'm going to present it to you anyway. And then what I would like, I would love to go into more detail into discussing the questions that Padova has arisen, but I suppose the time will be a little bit, but possibly in the discussion we can talk about that later on. First of all, let's start with the contents of the AI Act and what the member states are supposed to do about it. The new AI Act of the European Union, as we all know, is a piece of legislation that for the first time tries to implement a regulatory concept for this rather fast evolving field in the European Union. And although it is based on the general EU competence for the internal market, which is Article 114, and the legal basis for data protection measures, Article 16 of the Treaty on the Functioning of the European Union, its relevance extends far beyond purely economic questions or data protection issue in a narrow sense. We've seen that quite clearly already in Paco's presentation. And I think that's also relevant as far as the administrative implementation or the implementation by means of administrative law is concerned. A core focus lies on the field of fundamental rights protection, and even though it intends to harmonize the AI Act intends to harmonize the legal requirements for the new technology in the entire single market, it clearly attempts to raise the overall standards for safeguarding fundamental rights such as free speech, non-discrimination, privacy, the rights of defense. Artificial intelligence can, in particular, be used to create content which disseminates untrue or misleading facts. It can severely affect personality rights and control the behavior of humans. At the same time, artificial intelligence is a very versatile means to enhance content targeting techniques. Therefore, AI is a potentially very risky and potent means for influencing people and a source for disinformation and its dissemination. While, as far as collecting knowledge and enhancing economic efficiency is concerned, AI has an enormous potential for reshaping, among other fields, the world economic order. It can cause dangers for fundamental rights, like, for example, freedom of speech, and it can enhance threats to the plurality and reliability of information. It therefore is also a danger for the integrity of the democratic decision-making. The European AI Act wishes to address these risks and therefore contains some elements of a regulatory framework which complement the approach of the other big regulatory measure that we've seen in the recent past, which is the Digital Service Act, the DSA. Like this legal act, it follows a risk level oriented approach with the exception of some horizontal requirements which apply to AI systems irrespective of their risk level, including the overall transparency requirement in Article 50 of the AI Act. And in line with this approach, Article 5 of the AI Act prohibits some particularly dangerous and manipulative applications of AI, and it prohibits that directly and is directly applicable in the European member states. So there is no necessity of transposing it into international law. Other high-risk AI creations are subject to the obligations according to the Articles 8 and the following of the AI Act. They apply with some exceptions, for example, to AI systems intended, and I quote, to be used for influencing the outcome of an election or referendum or the voting behavior of natural persons in the exercise of their vote in elections or referenda, just to give you an example. And it consists in risk and quality management systems, conformity assessment procedures, and transparency obligations. High-risk AI services have to undergo a fundamental rights impact assessment. That's where the national authorities come into play. The AI Act establishes a notification and monitoring system for which the national authorities are competent. And here we are in the field what the member states are supposed to do. It therefore tries to mitigate the potentially negative impact of AI on, for example, the democratic process, as well as on fundamental rights, and it intends to minimize the risks that are connected to it. Nevertheless, the special rules on the high-risk AI services will only cover a fraction of the creations that can be dangerous for an undisturbed and manipulation-free democratic exchange in society. More generally speaking, therefore, Article 50, which is the general transparency obligation of the AI Act, sets a standard so that AI, which is intended to enter in a communication with natural persons or provides for synthetic audio, image, video, or text content, has to be recognizable as such. The obligation of transparency thus is another element in the attempt of the EU legislator to reduce the danger of AI-created content by publicly designating the potential doubts about its veracity and its authority. This transparency requirement is certainly a proportionate restriction of the fundamental rights of the creators of AI, such as the economic freedom under Article 15 and 16 of the Charter, or the right to free speech and artistic liberty, Articles 11 and 13 of the Charter. We were talking about the relations between the different interests that are involved, and we've got a rather clear decision of the AI Act itself in this field. It only puts a relatively moderate burden on them for the benefit of highly relevant societal and legal values. As far as the integrity of the democratic process, but also individual rights of the personality are concerned, a particular danger follows from deepfakes, just to give you another example, which according to the definition of Article 3, paragraph 60 of the AI Act, appear to represent real people, but are generated by AI and may be used to distribute, for example, misleading content with the seemingly real authority of the person being imitated. An obvious example of fake statements by politicians. Consequently, the AI Act requires deepfakes to be labeled, again, something which is directly applicable. A sanction mechanism is contained in the Articles 99 to 101 AI Act, which have to be transposed, which have to not transposed, but implemented, which complement the transparency requirement. It is, however, by no means certain that the implementation and the enforcement of these obligations will be able to successfully reduce all the dangers that stem from this new technology in terms of the integrity of information exchange and protection of fundamental rights. Second part. According to the AI Act, it has to be implemented and executed by the member states by August the 2nd, 2026, so this year or beginning of August, for most part of its provisions. Some of them are already applicable, some of them still have to wait, but the most part of it will enter into force on August the 2nd. Since the regulation is directly applicable in all the member states, the core task of the national implementation concerns the governance of the AI Act. That means the structure and the competence of the national institutions as well as the applicable procedure. This is in line with the principle of procedural autonomy of the member states and the principle of subsidiarity under European Union law. However, this procedural implementation is not an irrelevant or even secondary task. On the contrary, it can influence significantly the success of the legal act in question. Therefore, Article 4, paragraph 3 of the Treaty on the European Union sets limits to the freedom of the member state to decide on questions of an institutional and procedural nature by demanding that it meets the principles of equivalence and effectiveness. That's something which is well-established case law in the European Union. Nevertheless, according to the repetition of competences in EU law, it is part of the member states' competences to decide which, in addition to the substantive legal provisions of the AI Act, can be a more or less heavy burden for individuals and companies that are affected by the Act. So the member states have still got the competence to decide on the authorities, on the procedures, and they can obviously make the lives of the companies, of the individuals that are dealing with AI more or less difficult. Hence, the institutional and procedural design can have an impact on the market actors, as well as on the market itself. Even if the core regulatory principles and obligations in this field are contained in the AI Act itself, it is possible for a member state to choose an institutional and procedural design which either alleviates or increases the economic burden that the regulation is putting on the market actors. At the same time, institutional and procedural questions are relevant for the effectiveness of the Act and its regulatory concept. If the competent authorities are not capable of enforcing the Act or do not have the means to fulfill its different objectives and tasks properly, not only the member state in question will be in breach of its EU law obligation to transpose or to implement and execute the legal act in an effective manner, but in the case of the AI Act, it will also impair the overall structure of AI regulation in Europe and its ability to serve as an example of good practice on the international scene. It is true, however, that this argument applies also in the other direction. If the procedural implementation in the member states becomes so dysfunctional and cumbersome for the market actors that it impairs their ability to pursue their activities altogether or discourages them from developing and applying forward-looking and convincing AI solutions, which are in line with fundamental rights, for example, that can have a negative impact on the overall economic standing of the European Union in this, as I said, rather fast and evolving field, which is of utmost importance in the international economic relations. Third and last part. Therefore, the political question of how to implement the AI Act and the question of the appropriate governance model to choose is indeed impactful. It has been subject to some discussion and controversy in the German case, as the federal government, with the Ministry for Digitalization at the forefront, opted for a rather slim and reduced version of a governance model. The German draft legislation for the implementation of the EU AI Act is currently in the legislative procedure. it opts for a differentiated approach as far as the competent authority is concerned. Its general idea is to fit the competences of the AI regulation into the existing system as smoothly and unobtrusively as possible. Therefore, as far as AI issues are relevant for the financial market, as an example, the usual financial market authorities remain competent as market surveillance authorities for the AI Act. However, the core question of who should be the overall or the residual regulatory authority, that means the national market surveillance authority for AI, is in the vast fields that where there is no specific competence available, this question remains. Here, the federal legislator has chosen a specific administrative authority which already exists and which is the Bundesnetzagentur. Some of you might have already heard about that because it is a central German regulatory authority in the field of, among other things, telecommunication, energy, postal services, and so on. It is the main German authority for infrastructure, which is in charge of promoting competition in the markets for energy, telecommunications, post and railways. It therefore has a broad experience in the field of market regulation and will necessarily be affected by AI issues in its traditional fields of regulation anyway. Think of energy, for example, think of telecommunications. All these fields are most certainly be affected by artificial intelligence. So they will have to deal with that anyways. But now they've got the general competence as a market surveillance authority for AI. Adding AI market regulation to its portfolio of competence, therefore, is neither a surprising nor a far-fetched choice. The only question is whether this accumulation of competences in the area of market regulation does not necessarily have the effect of creating some sort of super authority, which it is already, as far as, for example, energy is concerned, a super authority that can in the end implement its own ideas of market, of competition, of regulation in nearly every relevant field of the network-based economy. The internal decision-making procedure of this authority is similar to the one that the authority in AI cases is similar to the one that the authority uses in its other areas of competence, and which is structured similarly to the decision-making of a tribunal. It decides in chambers of 3 and is entirely independent, 3 members, and it's entirely independent. That is something which we've got in energy regulation already, and the idea behind that is that these independent chambers will come to some even more independent decisions than, for example, a single decision maker could come to. In addition to its market surveillance competence in the field of AI, this German Federal Market Authority is also meant to build up a national competence center for AI. So there will really be some sort of AI control, how do you say that? AI competence build up in this authority. It will also be the single point of contact in matters of AI, and it will accumulate, therefore, a significant level of competence and power in this field. At the same time, the regulatory authority, the Bundesnetzagentur, is also competent for the complaint procedure according to the AI Act. So according to this legislative decision of the German, well, basically, until now, it's just the government because it is within the legislative procedure. But according to this decision, according to this choice, the Bundesnetzagentur is meant to be the core player in the field of AI and is also meant to set up the specific rules of conduct in the field of artificial intelligence. So what we will see, and that is something which we already know from the fields of energy, of telecommunications, is that the decision-making, that the question of codes of conduct, that the questions of how the market actors really have to act the most detailed decisions will be found on the level of this regulatory authority and probably less on the level of the legislator. It might be a wise choice to do that, to take some sort of independent authority in order to implement what the AI Act requires us to do. The AI Act certainly allows this option. However, knowing the powerful position of the Bundesnetzagentur in the field of energy law, I sometimes have my doubts whether this accumulation of competences within one really large and powerful authority is really a good idea if we want to come to independent decision making. Because yes, the authority is independent, but it becomes a powerful actor of itself, and that sort of might, let's say, compromise its independence. But that remains to be seen. So that's basically what I wanted to say about the German case. Unfortunately, nothing final yet, but still some sort of general idea of what might happen. Thank you very much.
Sorry. But I have to make Elvin co-host so she could share.
Okay.
Yeah, thank you, Elena.
So, thank you very much, dear Friedrich. It was very interesting because you didn't tell what would be the solutions, but you told us about the methodology, which is something really important. And afterwards, we know something more about Germany. That was the purpose of this meeting. So now, without further ado, I give the floor to our good friend, Professor Elvin Dalkılıç, that is there in the internet. She's in Turkey. She is sorry for not being here, but she's a specialist in these topics. And she has been in Portugal last week teaching about this. So she is, as we could see, all the students and the colleagues at the faculty, that indeed she is someone that we should listen to. And without further ado, you have the floor. Thank you very much, Elvin.
Thank you, Vasco, for your kind words. And hello, ELPIS family. I miss you all so much. And it's a pity that I'm not there in Padova with you, but I send you all my warm regards from Ankara. Now, after Frederick's presentation, I can continue with the remaining aspects of the EU AI Act. I have a presentation. Let me share my screen. Yeah. Now you can see it, I hope. Do you see it?
Yeah.
Okay, that's perfect. Well, I will talk about the novelties in the regulation of AI after the EU AI Act. First of all, why EU needs a regulation? We can answer that question by looking at the rapid growth of technologies, regulatory gap before 2024, and need to balance innovation and rights. But let me tell you that EU has always been criticized because of many regulations, over-regulated. Is it over-regulated? Is it too complex? That's what we should look at it. But is it better, as Professor Balaguer said, is it better not to regulate? It's up to discussion, I guess. Okay, let's have a look at the EU AI Act at a glance. It is published on 12th July 2024, and it's been in force since 1 August 2024, and its scope is a horizontal one. Anyway, the Act classifies AI systems into 4 risk tiers with proportionate obligations, which I will try to introduce. And also, there is a new regulatory category for general purpose AI models, and it also requires fundamental rights impact assessments for especially high-risk deployers, where Frederick mentioned in his presentation, and establishes the European AI Office as the central enforcement body. Okay, let's look at the classification framework. As I said, there are 4 classifications on risk-based. First, there is the category of unacceptable risk, and this is totally prohibited by the EU AI Act. Then there is the high-risk AI systems with strict obligations, and high-risk AI systems are important in a sense that public authorities uses high-risk AI systems. And then there is the group of limited risk, but the Act requires only transparency obligations. And there is the 4th group, minimal risk, and there are no specific requirements. So these all 4 categories are categorized depending on the risk it poses, especially to the fundamental rights and copyright laws. Look, this slide shows the prohibited AI practices embedded in Article 5 of the AI Act. Social scoring, subliminal manipulation, exploitation of vulnerabilities, real-time remote biometric ID, untargeted facial scraping, emotion recognition, and biometric categorization. These are all prohibited in the EU level. And as a regulation, the EU AI Act should be implemented, as you know, by the member states without any exception. Now, this is the high-risk AI systems. High-risk AI systems are widely used in healthcare, employment, law enforcement, education, migration, and justice. So high-risk AI systems should have a risk management, and I think the most important part is that Act requires human oversight in high-risk AI systems, because with the human oversight, it is thought that it could prevent bias or discrimination, and there is the documentation requirement. Okay, high-risk AI compliance obligations. I will not tell them one by one, but as you can see, I have highlighted human oversight measures. This is really important because during the decision-making process, it is required that humans should intervene this process. But as I told to my students, the article lacks specifics on when and how human oversight should be implemented. So it's not clear. I would expect that to be more detailed, but it is not. So I don't know how it will be implemented in member states. But of course, technical documentation and transparency to deployers and accuracy, robustness, and security are also important articles for the providers. But we should separate providers and the deployers in this regard. Deployer is the company or the authority which deploys the code, the system, but on the other hand, a provider is the one who uses the AI system. So providers in this regard, especially when it comes to high-risk AI systems, are mostly the public authorities. Now we have the general purpose AI. Let me try to explain it. It can be a little hard, but when I said ChatGPT of OpenAI, or when I say Google's Gemini, they are really good examples of general purpose AI. And general purpose AI refers to AI models capable of performing a wide range of distinct tasks, such as text generation and image recognition. AI Act in this regard, because it's a new category, regulatory category, requires transparency, copyright compliance, and risk management. So for the ChatGPT or for the Gemini of Google, AI requires these general purpose AI to be transparent and should comply with copyright law, and also there should be the risk management. As I said, it is a new regulatory category, and obligations have been effective since 2nd of August 2025. So as you can see, 24 providers signed the GPAI Code of Practice by August 2025, and it establishes industry-led compliance standards. So technical documentation, information and documentation to downstream providers, copyright law compliance policy, published training content summary, and of course should comply with the GPAI Code of Practice. And Frederick mentioned fundamental rights impact assessment. This is important. It is embedded in Article 27 of the Act, and it's a novel obligation unique to the AI Act. Who must conduct fundamental rights impact assessment? Public bodies deploying high-risk AI, private entities providing public services, and deployers of AI for creditworthiness or insurance pricing. So what is important, again, let me emphasize the human oversight mechanism. But for human oversight, the staff or the personnel who uses AI system must be aware of how the system works. And I guess training of the personnel, public servants are really important in this regard. And transparency requirements, maybe I'll be repeating after Frederick, but providers of the systems must ensure outputs of AI systems generating synthetic audio, image, video, or text are marked in a machine-readable format and detectable as artificially generated. When it comes to chatbot disclosure, persons interacting with an AI system must be informed that they are interacting with AI unless this is obvious from the context and circumstances of use. Deepfake labeling, deployers of AI systems generating deepfakes must disclose that content has been artificially generated or manipulated. And for the emotion recognition, deployers of emotion recognition or biometric categorization systems must inform exposed natural persons of the system's operation and process data in accordance with applicable law. And AI literacy obligations. core requirement in this regard, as you can see from the slide, providers and deployers must take measures to ensure to their best extent a sufficient level of AI literacy of their staff and other persons dealing with the operation and use of AI systems on their behalf. So this means in practice that there should be a training considering the technical knowledge, experience, education, and context of the persons concerned. And should encompass understanding of risks, potential harms, and safeguards associated with the AI systems used. But let me tell you that, of course, these provisions in practice should be aligned with the founding principles of the EU. So this is really important. And also the EU AI Act should be considered with the GDPR, General Data Protection Regulation. So they must be in full alignment. And the broad applicability, let me say, it's not limited to high-risk systems. It covers all providers and deployers regardless of risk tier. But still, I do believe that it will be up to discussion when the high-risk AI systems requirements will be in force in August 2026. Look, GPAI obligations are in force at the moment since August 2025. But what is important is when high-risk AI systems, as the EU AI Act defines, should obey the requirements of the Act. So when you look at Annex 3 of the Act, you will see the high-risk AI systems. As I said, mostly the public authorities use in healthcare, migration, justice, and law enforcement. And you can understand that they are all really very close connected with fundamental rights and freedoms. And as you see on August 2, 2027, there will be the full application. But there is the digital omnibus, and it is proposed November 2025. It may delay standalone high risk to December 2027 and embedded systems to August 2028. What is digital omnibus? Well, actually, it is a legal package, legislative package, and it was proposed in November 2025. And this legislative package designed to simplify, update existing digital laws, including AI Act and GDPR. So we'll see how it will be enacted. Will it change? I cannot say anything certain. So we have the European AI Office, then the national authorities, and the Act requires strong enforcement system. Especially, it is famous with all the fines. You know, a company, a provider could be fined to 35 million euros. Look, this is the enforcement architecture. For prohibited practices, the fine is up to 35 million euros. For high-risk violations, it is 15 million euros. And for incorrect information, it is up to 7.5 million euros. And this is huge. These are enormous numbers. European AI Office, in general, it is the central enforcement at EU level, oversees GPAI compliance, codes of practice, and cross-border coordination. National authorities should designate each member state, should designate a competent authority and market surveillance body, as Frederick mentioned. Then there is the AI board and the scientific panel, according to the Act. AI board is the advisory body of member state representatives ensuring consistent application. Then there is the scientific panel, and this panel includes independent experts advising the AI office on systemic risk classification. Now, let's have a look at the global landscape. As you see, the approach of EU is comprehensive risk-based. Key legal framework is the AI Act. And as I mentioned, there is a 4-tier pyramid. And yes, it is extraterritorial, and this is called the Brussels effect. And the enforcement is in the charge of AI office and national authorities. But when we look at the states, United States, it is sector specific and there is no federal AI law, and there is no unified classification, and it is limited when we look at whether it is extraterritorial or territorial. And China, it is interesting, it is content focused and state control, a central control mechanism. And there are 3 binding AI regulations. It is content and algorithmic focused. And yes, it is extraterritorial, especially if the content is used in China. And we see a central authority, CAC, and the sector regulators. So, key takeaways. All in all, the EU AI Act is the world's first horizontal, legally binding AI regulation, and it is already being enforced or for prohibited practices and GPAI models. Risk classification is the gateway to all obligations. Misclassification carries severe financial consequences. The fundamental rights impact assessment represents a novel intersection of human rights and AI governance without precedent in other jurisdictions. And GPAI model regulation introduces obligations at the foundation model layer, at first in any legal framework with systemic risk provisions for the largest models. And the extraterritorial scope and phased enforcement create a Brussels effect that is shaping AI regulation globally, from US state laws to China's algorithmic rules. And finally, the digital omnibus may recalibrate the August 2026 high-risk deadline, but organizations should prepare now, for the regulatory direction is irreversible. Well, thank you for listening to me, and thank you for your attention.
Thank you very much, dear Elvin, for your overview of the regulations. It was very interesting, and you give not just a general panorama of the rules, but also the schedule for its implementation. So thank you very much. And last but not least, now I leave the floor to Professor Elena Buoso. She's going to tell us about the only country until now that done the homework. They were the best pupils here, and they were able to find a law. And as far as I know, and as far as I've seen, a good law. So congratulations, and we'll be wanting to hear you about this. Thank you very much.
you very much. I have a presentation. I try to find the it's not working, so maybe this one. So the human being is always the weak, or not always, but sometimes the weak. So, and so. Well, thank you very much also from my side for. I am the last today, and I will skip many parts which other speakers has focused on, and so I will concentrate about the Italian law. So indeed, and as you see, or not as you see, but I also have to disclaim that I use AI for preparing this presentation. So we'll see it's quite a typical, the images are quite typical AI products. So why AI regulation matters, we all know, but indeed the Italian law number 122 from September 20, so for last September, is the first European, or Italy is the first European country that has adopted a national framework coordinated with the European AI Act. It is a law of principle. So as I said, I will skip the part about the risk categories of the AI Act, and I just come to our law. And the first thing, which is quite not peculiar, but it's quite representative of the law. It is writes down very anthropocentric systems, and as law of principle, it is what we call a parameter law. So between the Constitution and all other ordinary laws. So it could be used. It will be used from the by the constitutional courts for the new, for all the new, to judge all the new ordinary legislation about AI and about digital administration and so on. And it could be directly used by the judges and by, for my point of view, particularly important by the administrative judges also to, for as parameter for their decisions. And regarding the administrative judges, I have to say that many of those principles written in the Italian law come from the administrative jurisprudence, because the administrative courts were the first one to challenge or to judge about automatic or completely automated decision. And as we has no indication by the legislator, and we find some of the concept of algorithmic legality in the Italian law now. So general principle or the article 1, I decided just to summarize for you the law, and then maybe in the discussion or today evening we could also go more deeply. So we have, the law is a very short one for Italian standards because it has just 28 articles. And in the first three articles, we find the general principles. And so the objective, the scope of the law is to promote the responsible, secure, transparent use of artificial intelligence while protecting fundamental rights, democracy, human dignity, and personal freedoms. And to do so, it as a criteria for the further legislation and for the application of the legislation, it says that every act recurring to AI, but also the development and the use of artificial intelligence itself must respect fundamental rights, non-discrimination, transparency, security, data protection, and democratic values. It could be particularly relevant, as you already said, in regarding the role of a private entity in developing the system used by the administration or by our juridical system. So the topic of transparency, accountability, and governance was also already cited. And regarding this matter, the Italian law states that citizens must be able to understand, so not just to know that, but to understand that. It's quite, or it's slightly different, but it's very significant difference when they are interacting with AI system and what kind of AI system, so with what kind of autonomy decision the system has, which data are being processed, which from personal data, and how automated decision affects them. So the goal is to prevent the opaque black boxes, the algorithmic opacity, but also because, so I could just mention it, Italy has, or in Italy, the administration has not democratic legitimation from itself. So the legitimacy of the Italian administration is just by doing in a very competent and professional way. And so it is important that the accountability and the decision are made by the administration itself, and not to fall in this very tempting mechanism to say, oh, the machine or the algorithm says so. So it is quite an important matter for our administration now. The Italian system, not only in this law, actually since 2018, has a very complex and quite well-developed system of national governance of about digital matter and AI matter and cybersecurity, of course, due to the directive on digital services, NIS 1 and NIS 2, but also Italy added some peculiarity. Just to summarize, we have two Italian authorities dealing with those matters: the Agency for Digital Italy, AGIT, Agenzia per l'Italia Digitale, and the National Cybersecurity Agency. They are very very close to the government and very close also to the secret services and national services regarding the National Cybersecurity Agency, and the Agency for Digital Italy is more, or should be more, in the initial idea and independent authority, but then in the further developing, they were attracted, some of them competence were attracted by the government, the central government, and to balance this not lack, but this diminished independence in the political strategy and political decision, or they added a very they added to those agencies a more technical and professional and technical part regarding who is sitting in the board, and also how the procedure has to be completed. So the AGIT is responsible for administrative coordination and technical guidance of all digital infrastructure and systems in Italy, and the ACN focuses more on cybersecurity and the protection of strategic infrastructure, with a very, very wide and very general concept of what is cybersecurity national interest in this matter and digital sovereignty. The law has then quite an important part about AI in public administration and healthcare. And of course, I choose, not of course, but I choose a picture for you of how at the beginning we intended digital administration, but how it is not digital administration. So for many years, and so I would say 15 years, digital administration was just put the analog administration in a digital form and to scan the acts, but now we are really quite accelerated. We had a very fast development. Well, not comparable to the north, to the lender from the north, but I think for Italy it was quite remarkable. And the law establishes that automated decision must be traceable and gives also details for this legality algorithm requisite. The human oversight, so the human in the loop and over the loop, must always be guaranteed. Citizens have the right to know the criteria used by algorithm, and these criteria must be known or must be communicated in an understandable way, because this is often the problem. It's not a matter just of transparency, but also of comprehensibility, understandability. And automated decisions must always be, or they are always challengeable, but it is not just by this, or it is not stated by this law, because it is a consequence of our constitutional framework, the challengeability of, or the actionability against administrative acts. And in this, also in the current time, we have many Italian administration using algorithm and sometimes it is mandatory to use automatic decision or automated, not decision, automated procedure, for example, for rankings and competition in the area of public procurement. It is not just a favor, it is sometimes mandatory, because there is the idea that it is more impartial and more efficient. tax control, most of them are completely automated. Some administrative procedure in the inquisitory part and data analysis, and sometimes the delivery of public services at the local level. Most of the online procedure and the interlocution with the public service is then automatized and thanks to algorithm. The other part is healthcare. Yes, healthcare, and in this matter, the law states that doctors remains responsible for clinical decisions. Also, the kind of decision where AI is largely used because it allows the use of big data, and for some diagnosis is very profitable. So AI is only a support and not a tool, and health data have a special protection, and so not only to prevent bias and discriminatory outcome, but also a special protection, so security controls. Also because in the last 3 years, we had some notorious and quite critical data breaches, and they were mostly against health institution and health institution, I could say, or the health ministry. A part of the law is dedicated to employment, and I will just concentrate about the second part, so employment for the private party, but for us also as lawyers, it's quite interesting. Article 13 that concentrate on regulated professions, so professionals such as lawyers, doctors, and engineers and accountants must inform clients when AI tools are used. They remain fully responsible for their professional services, and they cannot entirely delegate decision-making to automated system, and also claims and so on. And on this regard, we had last year the first cases where it was clear that a lawyer prepared all the acts by using AI, and this was challenged then by the judge. So there is the idea now to introduce sanction for this conduct. And apropos for sanction, the law focused then on deepfakes and criminal protection, and introduces also on this regard criminal provision concerning the unlawful dissemination of AI-generated and manipulated content. Not only in the perspective of protecting individuals, but also in the perspective of protecting democracy, as we heard from in the previous speech, as in the first speech, about the danger of deepfake in influencing the public opinion and the consensus. Of course, it is a general regulation. This is the first general regulation, so it could be optimized, and some open questions and challenges are still there. The first one is the problem of enforcement and of effectiveness. So the legal framework must be effective, and it requires adequate controls, strong and independent authorities. And so the problem I just mentioned with the position of AGID and ACN regarding the central government, but also technical expertise and financial resources to be effective. Also because technology evolves faster than not only than legislation, but also than administration sometimes. And so the enforcement could be a problem, or the update for monitoring could be a problem. Then there is the problem of the big tech companies and digital sovereignty. But I think those issues are very, very common for all European countries. So, and in particular, the problem with technological dependence and market concentration. Europe is attempting to build an alternative. Italy as well. We are speaking about an Italian, some Italian projects, but in my opinion, the winning choice would be an European one and not just a national one. The third issue is digital literacy, and not only for the public servants, public administration, but also for the population. Of course, we have, and so Italy has a very old population, and the problem of digital divide is very, very present. So it is not just so regulation is one thing, but society needs to be to adequate education, and on all levels. So not just or less for the younger generation. For them, it's more, I think, a question of awareness, or as we talked yesterday, from go above and the digital tools, but for other generation is really a matter of how to do very simple thing. And returning to or coming back to the digital services and so online services and online procedures, it must be granted that there is also the normal possibility to go to the counter for them who wish or who could not have a digital device. And then the last problem is the awareness or the about that AI is not neutral, and so the challenges for democracy and ethics. In all the topic I mentioned, healthcare, but also public services and so on, we could, although we have to be very attentive, and the law tries to focus the Italian law also by reconstructing or trying to build from the beginning a system where it's clear who is in charge for what kind of decision and who is in charge for what kind of control. So concluding, this law is a very good, as in my opinion, is a very was more than just the beginning. So it's a big attempt to create a balance, governing the objective or governing this innovation with in accordance to the democratic principle and fundamental right. To balance the promise of AI and the risk of the AI. The challenge is building a society capable of using this technology without losing the human and political and ethical control. But I think what is useful and also is not so obvious is that we are obliged to focus on what decision matter most for us, and what decision in all topics, but in particularly by the legislator, for example, or by the administration, must remain human. So thank you very much.